The first issue is that the disqualifications of members of parliament and legislature of state as per para 2 of the 10th schedule is violative of the basic structure of the constitution of India. Under this, the constitutional amendment actually breaches the feature which breaches the basic feature of the constitution is liable to be declared unconstitutional. If the Lordship pleases, then kindly refer to citation 2 of the Moot Memorial, where, in the case of M. Nagraj versus Union of India, it was clearly said that in order for any law to be approved, the two tests has to be passed. First is that the reasonable classification. Second is the absence of arbitrariness. The reasonable classification must have the intelligible differentia and the rational nexus between the object and differentia. However, Lordship, there is no intelligible differentia present in the 10th schedule because the people who are situated on the same footing, they are being treated differently. First, the members of the Legislative Assembly who belong to a political party, if they indulge in the defection by changing their party affiliation, they are excluded. Secondly, the independent members who are not associated with any political party, and even if they come up with other political parties with their support, then also they are being disqualified. Secondly, Lordship, the classification suffers from the evil of over exclusion as the differential is takes in the bona fide dissenters as well, and even if there was a genuine cause behind the dissenting. Secondly, the differentia must have a rational nexus uh, between the basis of classification and the object which it seeks to achieve. If the Lordship pleases, then kindly refer to citation 9 of the Moot Memorial, where in the case of state of Gujarat versus Ambika Mills, it was it was said that the classification is deemed bad in law if it suffers from vice of under or over exclusion where the state benefits or burden person who are similarly situated. Lordship, in the 10th schedule, the intent behind was to curb the evil of unprincipled floor crossing and defection. The classification has completely failed to address the issue of unprincipled floor crossing as it exclude the legislature who defect to other party just after the election, that is within 6 months of their election. Secondly, Lordship, the classification is patently arbitrary because the 10th schedule is denying the equality, because denying the equality to equals would amount to arbitrariness. If the Lordship pleases, then kindly refer to citation 11 of the Moot Memorial, where in the case of E.P. Royappa, versus State of Tamil Nadu, it was clearly established that it was held that manifest arbitrariness is established when the legislator acts in an irrational and capricious manner without determining the adequate principle. In that very judgment, Justice P.N. Bhagwati has clearly said that equality is antithesis to the arbitrariness.
I'm so sorry. There was some technical issue. I was removed from the court. Can we go back a bit, like 2 minutes of your arguments? Court Master, comp of this 2 minutes. I was unable to hear anything at all.
Shall I start in between?
I think you were in the part of the classifications not based on intelligible differentia.
Right. I got it.
Okay, Mahi, I have one query.
Sure.
You talked about equality, right? About there shouldn't be any discrimination or arbitrariness in amongst equal or people who are into same circumstances, right? Now, how would you differentiate, or is there any difference between an independent candidate A person who has independently contested an election and got elected on his own, and a party and a candidate or a MP or an MLA who has been elected on the symbol of some party, on the goodwill of some party. Is there no such difference? So is
Uh,
not they are not they bound by it, bound by the party which? Is it can it be considered as arbitrariness then if they don't obey the party whip on whose symbol they have been elected? Is it arbitrariness to differentiate?
indeed, ma'am. Indeed, Lordship. I would like to say that the 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 country Indigo was having a parliamentary democracy, and where the dissent is a very important important element of the democracy. Therefore, there must always be the scope of dissenting opinion in any party, and if any member is putting their dissenting opinion with a bona fide and there is bona fide reason behind it, and if that person is not getting the chance, then that would amount to arbitrariness, definitely. uh, and in case of independent member, lordship, like if the nominated members who belong to a party, if they change their party within 6 months, then uh, there is no anti-defection law which will apply to them. But that's not the case in the case of independent members. However, both are getting elected through an election, so both should be getting the equal opportunity and both should be getting the same stage. Therefore, if we'll differentiate, then it would lead to arbitrariness.
Can you give an example of this happening, discrimination happening, a real-time example of something like this happening in our parliaments or any of the legislative assemblies of Indigo?
Um in the legislative of Indigo, like the facts were silent in this. As
There's a reason you as an NGO have approached the Supreme Court that this is happening a lot in India or in Indigo. And so one of the reasons could be any of these happening a lot, right? In any of the legislative assemblies or the parliament itself. Now, what led to filing of this petition? Why was this petition filed in the first place?
Indeed, Lordship. Lordship, here in the country of Indigo, there was, after the election, the people were trying to change their party, and therefore the anti-defection law was brought in. And after this, the Jan Seva has filed the writ petition in the Supreme Court to nullify it on the ground that it is unconstitutional. And it's the like there are various grounds on it that it was arbitrary, there was not reasonable, it was not reasonable, and it was violating the freedom of speech and expression, which is already given in under article 194 clause 2 of the constitution of Indigo, and Article 19, Clause 1, and uh, uh, which I'll be further dealing. Like it would also violate the principle of national justice, and on these grounds they have filed the writ before the court.
Continue.
Uh, shall I resume from intelligible differential, Lordship?
Yes, please. Ma'am, if you don't have any issue, I'd like to be heard
Yeah.
about that.
Right. Uh, So there was no intelligible differentia in the 10th schedule because the people who were situated on same footing, they were being discriminated. How? First the members of the legislative assembly who belong to any political party, and if they indulge in defection by changing their party affiliations, they were being excluded. But at the same time, the independent members, even if they come up with the support of the political party, then also they were being discriminated and they were being excluded. Therefore, we can see that there is no intelligible differentia, and also it suffers from the evil of exclusion because the differentia is taking in the bona fide dissenters as well. And even even if the dissent was based on a genuine reason. Second is that the differentia must have a must bear a rational nexus between the basis of classification and the object is sought to achieve. If the lordship pleases, then kindly refer to
You are
citation.
getting disconnected, speaker. Am I only having this issue, or is this? Please continue, Mahi.
Yeah, sure. Lordship, if the Lordship pleases, then kindly refer to citation 9 of the Moot Memorial, where in the case of State of Gujarat versus Ambika Mills, it was held that if the classification is deemed bad in law, if it suffers from vice or under or over exclusion, where the state benefits or burdens persons who are similarly situated. Lordship, the intent behind 10th schedule was to curb the evil of unprincipled floor crossing and defection. However, the classification has failed to address the issue of unprincipled floor crossing as it excludes the legislature who defect to other parties after the election, that is within 6 months. Next is that the classification is patently arbitrary because denying equality to equals would amount to arbitrariness. If the lordship pleases, then kindly.
Just like I think I'm having issues again with the connectivity.
Am I
Ma'am,
audible?
can you hear the speaker properly?
Yeah, I can hear.
Now you are. Kindly speak again.
Uh, if Next is that the classification is
Can you hear me, speaker?
patently.
I am able to hear.
It's my issue only.
Try to stop the video. Maybe then the connectivity improve. Speak something, Mai, so that we can check whether.
Sure. Second is that the classification is patently arbitrary because lordship denying equality to equals would amount to arbitrariness. If the lordship pleases, then kindly refer to citation 11 of the Moot Memorial, where in the case of E.P. Royappa versus State of Tamil Nadu, it was said that manifest arbitrariness is established when the legislature acts in an irrational, capricious, without determining the principle. As in the same judgment, Justice P.M. Bhagwati has said that equality is antithesis to arbitrariness. If the lordship please, under para 2 of the 10th schedule, it was clearly said that it disqualifies the legislator for voting against the party to curb the political defection. However, lordship, it does not disqualify the legislature who change their party affiliation just and play the game of defection. Not, the council seeks permission to proceed with next sub-issues.
Please continue.
Much obliged, Your Lordship. The next sub-issue is that the 10th schedule abrogates the legislature's speech and expression. As given under Article 19 of the Constitution, it forms the basic structure of the Constitution, and it cannot be abrogated in any circumstances. Under Article 194, Clause 2, which categorically states that a member will not be made liable to uh, um, any speech or vote given by him in any proceeding. However, Lordship, the 10th schedule invalidates the vote that is cast by member if such vote is against the party whip. The next sub issue is that the amended 10th schedule violates the principle of natural justice. If the Lordship pleases, then kindly refer to citation 16 of the Moot Memorial, where in the case of Keshwan and Bharati versus State of Kerala. It was said that equality of status and opportunity of an individual mentioned in preamble of the constitution forms the basic structure of the constitution. If the lordship pleases, then kindly refer to citation 17 of the Moot Memorial, where in the case of Quixote Holland versus Zalichu and others, it was said that integral aspects of the free and fair election is the provision for the adjudication of the election dispute. However, Lordship, the 10th schedule does not adhere to the aforesaid principle of an independent authority because
How is
there is
Kyoto connected here? How is Kyoto here? You said free and independent election. This chapter deals with post-election issues.
Indeed, Lordship, under this Quixote Holland versus Zalichu, the issue was that whether the speaker is an whether the speaker should be given the authority to adjudicate the dispute or not. So this was the issue in this case, and that was answered.
So how is that connected to free and fair election?
Indeed, Lordship, while giving the judgment, it was said that there must be like for free and fair election, there must be the adjudication of the disputes of the election, and therefore I'm the connecting with the natural justice. There are some grounds of natural justice which it should have while adjudication of the disputes, that there must be an independent authority for the adjudication of disputes, but as given under uh, para 6 of the 10th schedule, it says that the chairman, or in the case maybe the speaker, shall be the adjudicating authority. So, Lordship, I would say that the speaker is the person who is chosen by the majority of the persons of the house, and accordingly, if the majority of the people will choose if they will choose the speaker, then definitely they will choose their loyal person, and even after the member who will become the speaker, they will that person will also be loyal. And
Doesn't
if
the
they will,
speaker take an oath on the constitution itself before being appointed?
indeed, Lordship, uh,
Won't he be bound by the constitution and the rules as set in the constitution for adjudicating on any of the issues?
indeed, Lordship, he will be bound by it, but anyhow, he will try. He will try to make profit to the people who have chosen him.
But then, is there a scope for review of his orders?
Lordship, uh, in case when it is arbitrary, then in that case, sometimes the judiciary has also been given the power to adjudicate on the disputes.
So
If
what is
if
the
it's
issue then? And tell me that the Kyoto upheld the provision for appointment of the Speaker of the House, right?
right.
So that's a
Uh,
res judicata matter. So why are we
indeed,
arguing on this matter?
Indeed, Lordship. Lordship, what I'm trying to say is that there are very few circumstances when the judiciary comes in comes in and takes the place of legislature, because there are a lot of times when the speaker is only giving the sole authority, like in the case of Quixote also,
Hmm.
the judges have said that the speaker will be the sole authority to adjudicate the dispute, and
Hmm.
that is why the side petitioner is saying that he is not the person who is an independent authority, because there will always be chance of biasness in him, and that will lead to the absence of principle of audi altrum partem, uh, and 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 therefore the the
What is the principle of audi alteram partem?
the principle of audi altrum partem is that no person should be unheard. It implies that there must be a fair trial of the case, and that is why we are saying that if the speaker will be the adjudicating authority, then there will be no chance for for the fair trial.
Which judgment gives the power of Supreme Court to look into the judicial review of the orders of the Speaker of the House?
Lordship, like we have came up in under Article
You have come
136.
under Article 36. What I'm saying is there any specific judgment which provides for judicial review of orders of the Speaker?
Um,
Because I believe it must be a covered matter then.
the my co-counsel will be in a better position to deal with the issue.
Okay.
The
Tell me
counsel
something.
number
If we today go ahead and we pronounce an order saying that the Speaker of the House is not an authority which can decide on a matter, it will have to be court. The next thing you will do is come behind judges and their political affiliations, saying, I don't want this judge because he is connected to this party. Isn't this the same thing? Both the judges as well as the Speaker of the House are bound by the Constitution of India or Indigo in this matter. So
Indeed,
my
Lordship.
question is the powers under that.
Indeed, Lordship. Lordship, as we have filed the writ, we are itself questioning the constitutionality of the anti-defection law, and uh, even if the judges will give the power to the speaker, therefore we say that he should not be the authority. Instead of the speaker, there should be some other authority who should come in and who will not be related with any party, and uh, this could be any tribunal or something, but the speaker should not be given such power.
Your prayer is to declare the disqualification of members of parliament as legislatures of state as per the para 2 of 10th schedule as violative of basic structure of constitution, right?
Right, sir.
So if we declare this as unconstitutional, would you like to have a prayer for directions to the Union of India to frame another rules for anti-defection law, or do you want it to be back in the days of horse trading?
We would like to like we would pray for the legislature, or to give the judiciary to direction to them to make some better laws at the place of anti-defection law, which would not be which would not be violating the fundamental rights, or would not be arbitrary, and that would be reasonable.
But what if this is under the benefit of the legislature? Do you expect the Supreme Court to frame those rules? The legislature won't be intent on framing of these rules for anti-defection because it's beneficial for them. So in that case, can the Supreme Court does the Supreme Court has the power to issue such directions or create certain rules for anti-defection?
Indeed not, Lordship. We have just came to the Supreme Court for declaring this law to be unconstitutional, and it is completely the power of the Parliament to make such laws. But at our place, we can just pray to pray.
What you're asking is again opening a Pandora's box, right? We declare this as unconstitutional in the next 1 year or 2 years till the legislature forms a rule. We are in the dark and there's horse trading going on all around. So you need to have a prayer for that as well, I believe, for setting up rules or having better defection laws or having it in time-bound manner.
Like we would incorporate in further, like if we'll file PIL later on.
Okay, continue, speaker. Finish your
Uh,
arguments.
yeah. So from side petitioner, we have argued from 3 points. That first one is that it is unreasonable, it is completely arbitrary. Second is that it is violating the freedom of speech and expression, and third is that it is violating the natural justice. And with this, the council number one uh, finishes its argument, and if the lordships are satisfied with the arguments pleaded, the council seeks permission uh, to give the opportunity to the council number two to
Please.
proceed with. It was pleasure arguing before the court. Thank you so much.
Speaker number 2.
Greetings to the bench. Before I proceed with my submissions, I would like to confirm if I am both audible and visible to the bench.
Yes, you
Yes.
are.
Carrying forward the queries put forward by the honorable bench and putting up my submissions, I would like to seek permission to begin with the pleadings for the second issue.
Please begin the pleadings.
Your Lordship, the second issue is that the Speaker or Chairman under para 6 read with 7 of the 10th schedule does not satisfy the requirement of independent judicial machinery and is subject to judicial review. by the Supreme Court under Article 136 and 32. I have two
The
submissions in regard.
the same question
Addressing,
you're asking your learned speaker, can you address on that first? Is there already
indeed,
judgment to this issue?
Your Lordship, in the landmark case of Kyoto Holon versus Achilu, the minority opinion of the justices pointed out that the Speaker's tenure does not fulfill the requirement of independent adjudicatory authority.
No.
Further, constitutional expert Mr. MP Jain has highlighted the tendency of speakers to favor their party.
Okay, continue.
Addressing the sub-issue that the Speaker does not satisfy the requirement of independent judicial machinery. Firstly, I would like to put forward that it is imperative to address the feasibility of impartiality in the Speaker or Chairman's constitutional duties. The political affiliations of the Speaker, coupled with their sole authority under the 10th schedule, clause 6, raise legitimate concerns about their impartiality. Constitutional, as stated earlier, constitutional expert Mr. MP Jain highlights the same and suggests a transfer of disqualification decision to a non-partisan, like the election commission to ensure fairness. Further, in the landmark case, Kyoto Zachilu, speak the questions was raised by minority decision that it does not fulfill the requirement of independent adjudicatory authority. Justice Verma's advocacy for an independent body to handle legislative members' disqualification resonates with the same. And he puts out with the principle of nemo judox in causa sua that no one should be a judge in their own cause, since the majority party decides the speaker. If members changing the affiliation to majority party, speaker decisions tend to be biased. Furthermore, conferring adjudging powers to the speaker or chairman of the legislature infringes upon judiciary's domain, violating the principle of separation of power, which is a cornerstone of basic structure of the constitution. If it may please your lordship, please refer to section 21, page 5. It is supported by the authority occasion in the Bharti case. Further, each organ of the state, that is the legislature, executive, and judiciary, must operate within their constitutional spheres to maintain the balance of power and uphold rule of law. This harmonious functioning with their respective constitutional spheres is essential for achieving their goals. If it may please your lordship, please refer to citation 22, which authorizes this statement with Indira Nehru Gandhi versus Srinivas Narayan case. Uh, In conclusion, the role of Speaker in the 10th schedule, given their political affiliations, can lead to questions about their impartiality, and by extension, a violation of separation of powers. It is therefore humbly submitted that the current framework under 10th schedule does not satisfy the requirement of an independent adjudicatory machine.
But the
Your Lordship,
Speaker's decision is subject to judicial review. The Supreme Court has every power to review the Speaker's decision.
indeed, your ladyship, respectfully adding to that, Kyoto Holohan versus Achilu case clarified that a speaker decision is subject to post decision in the time suffered to the respected elected member. It might compromise with the judicial integrity. Uh, since the case very clearly distinguishes post decision review and um, technicality of the decision. Only the impartiality can be questioned post decision. I will be clarifying on the same point with my further submissions in the same regard. If
Continue,
it may
please.
please your, yeah, much oblige your ladyship, much oblige your lordship. It is therefore humbly submit. If your lordship is satisfied, I may proceed with the submission made in the continuity of the query. Counsel seek permission to proceed with the second submission.
Please
No,
proceed.
I think just a sec. Continue.
Much obliged, your lordship. The office of the speaker, as per 10th schedule of the constitution, act as a tribunal when adjudicating disqualification petitions. This
Yes,
position
continue.
This position has been held in landmark cases such as Ravi S. Nayak
Hmm.
and Rajiv Singh Rana. If it may please your uh, lordship, please refer to citation number 24 and 25 on page 5 of our memorial, where the Supreme Court affirmed that decisions made by Speaker and Chairman are indeed subject to judicial review under Article 136. Furthermore, the apex court in Kesham Meghchandra Singh versus Honorable Speaker Manipur expressed concerns over the extensive power vested in the Speaker, suggesting a need for checks and balances in line with the constitutional basic principle. Moving on to the powers of the Supreme Court under Article 32, it is imperative to note that the court has the authority to issue necessary writs for the enforcement of fundamental rights, including the freedom of speech and expression. The right to dissent, as highlighted in Romila Thapar versus Union of India. If it may please your lordship, please refer to citation 29, page 6 of our submission. It is referred as a cornerstone of democracy, allowing for multitude of voices and opinions within the political spectrum. Carrying it forward, in the state of Rajasthan versus Union of India, it was held that courts should not shy away from adjudicating matters under political authority.
But
Dissent is crucial for democracy.
tell me something. The speaker is supposed to be, when a elected representative or a nominated person is appointed as the speaker, the basic understanding is that he will be impartial, right? When the house has equal votes for, let's say, an issue, his vote becomes the deciding issue. Am I right?
Indeed, your lordship. But respectfully adding to that, there is no provision in the 10th schedule which mandates that a speaker must uh, leave their party membership or their party affiliations. If that was the intent while adding
Is
this
there a rule?
amendment,
Is there a similar rule like this for the appointment of the President of India? Does the President have to leave his political party? Because the Speaker of the House is similar to that of the President of appointment. The appointment similar, not the same powers, of course, but it's similar. So tomorrow, obviously, even the President was a political person before his appointment, and you may then claim that the President also has his biases.
your lordship, the council seeks ignorance on that point.
It's okay. So there are two parts to your arguments, I believe. First is that he's biased. Secondly, judicial mechanism, referral to judicial mechanism, right? Am I right?
Indeed, your lordship.
But I think the previous orders of this court are pretty clear that there's a judicial review power of the orders of the speaker. Even if, let's say, tomorrow they are biased, you can always approach this court and get a relief.
Indeed, your lordship. The review, the power of Supreme Court to review is on the technicalities of the adjudicating mechanism. It's not on that. It does not assure to uphold the right to dissent of members. What we are pleading is in line with the right to dissent. That it is crucial for democracy. If we don't allow dissenting dissenting members,
Okay.
it can lead to democratic turmoil.
Correct. It is
We
true
are
that there should be a right to dissent. It's fundamental to our democracy. But in the name of right to dissent, then horse trading starts. In the name of dissenting, I do not agree with the party line on moral grounds, on this ground, that ground. A person will switch sides easily if there is no anti-defection law. How would you address this? This will be
respect,
a easiest way then.
respectfully submitting in that regard. Your leadership, 10th schedule is silent on addressing genuine genuine defaulters or genuine um,
How would you
defection.
differentiate that? How would you differentiate that? Is if we are to do away with this legislation, how would you address these things?
Ma'am, your leadership, a fair adjudication process would ensure that proper reasons are from the side of the dissenting member. Uh,
Speaker, this is already,
ins-
I think, a settled law. Then non-speaking orders are violative. So it's under assumption that a speaker of the house will also not be passing a non-speaking order. It will have to be detailed. It will have to have every reason why whatever is giving for qualification or disqualification, whatever it may be. And in that case, then there's always this, if it's a non-speaking order, then you can definitely come to the Supreme Court, get your relief.
Your Lordship, Schedule 10 gives power to the Speaker or Chairman to disqualify members who defect. The Schedule 10 is silent to allow membership or not take note of the defections if they are um,
Can you
if
give
they are
us a
genuine.
real-time example of this happening in any of the states of India? Where the speaker has gone beyond his powers. Something which has happened recently. There has to be a reason for you to file this PIL. So can you give us the reason of the speaker going above and beyond his powers or being partial or biased?
Because you are an NGO filing the petition, you are not the affected party. Then means you are neither a disqualified MP nor a disqualified MLA.
Then it might be a politically, interested PIL. So is there any specific instances which you can recall or provide us that this happened and this is the order of the speaker?
In the recent instances of held in state of Maharashtra and Karnataka
Hmm.
assemblies, uh, the political mandate gave majority seats to a different party,
Hmm.
while the ministerial faces were same. Other elected members and party members who would support and make that majority to give them the ministerial face and chief ministerial face changed. Therefore, few faces played the game uh, against the whole uh, conscience of people who elected them.
You're not sure about what happened in Maharashtra? I don't think this is what happened in Maharashtra. And even in that case, literally both the parties were before us. And we referred the matter back to the speaker to pass an order so that could be reviewed. If my facts are not right, wrong.
Indeed, Your Lordship.
Even in that case,
Uh,
I believe we gave powers to the speaker to decide on the matter in a time-bound manner. Do you have a reference to the order passed by us? The Supreme Court, I mean.
I apologize on that point, Your Lordship.
No issues. You may conclude your arguments. Time is up, right, Court Master?
In conclusion, we plead the Supreme Court as the guardian of Constitution has jurisdiction to review the Speaker decision, both under Article 32. Your Lordship, putting Article 32 in our point differentiates that Article 32 will ensure that the decision is reviewed before a final adjudication, while Article 36 review only ensures adjudication post a decision. Uh, um, Summarizing our article, it is our contention that such review is not only within the court's purview but also essential for the preservation of democratic values and the rule of law. If it may please your lordship, counsel seeks permission to read out the prayer.
Please read out the prayer.
Wherefore, in the light of the issues raised, arguments advanced, reasons given, and authorities cited, it is most humbly prayed that it may be pleased to, firstly, declare that the disqualification of members of parliament and legislature of state as per para 2 of 10 schedule is violated of basic structure of constitution. Secondly, declare that the speaker or chairman under para 6 read with 7 of the 10th schedule does not satisfy the requirement of independent adjudicated machinery and is subject to judicial review by the Supreme Court under Article 136 and 32 of the Constitution, and or pass any other order, direction that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience, all of which is respectfully submitted. And for this act of kindness, the petitioner duty bound shall ever pray.
Thank you, speakers.
Thank you so much.
Okay. Speaker 3, right? For the respondents now. Union of India.
Yes, Your Lordship.
Okay. Vaishnav, you will be starting on this?
Yes, Your Lordship.
Okay.
The council seeks permission to address the bench as Your Lordship, Your Ladyship, the bench, and the court.
Continue. You don't need to seek permission, sir. Continue.
Your Lord, With the permission of the court, counsel would like to proceed to the issues. Your Lordship, before proceeding to the issues, counsel would like to reserve 15 minutes each for each, both my counsel 1 and counsel 2, Your Lordship, and 2 minutes for the rebuttals.
Does the respondent get rebuttals?
I mean, sir, rebuttals. Sir.
Sorry, rebuttals. Okay.
Sir,
Got it.
just a minute. In total, it should be 30 minutes. You need to complete in total within 30 minutes.
Reserves 13 minutes, counsel 1, 15 minutes for counsel 2, and 2 minutes for the rebuttals, Your Lordship. Your Lordship, this is counsel 1 dealing with issue 1 and 2, and co-counsel counsel 2 will be dealing with issue 3. Your Lordship, issue 1 is whether para 2 of the 10th schedule of the 10th schedule of the Constitution is constitutionally
Just a sec, I think there's a connectivity issue again on my end. Please go ahead.
Your Lordship, learned opposing counsel, that Speaker 1, had brought in the case of N. Nagaraj and Ambika Mills to say that it suffers from intelligible differentia and no rational nexus, and also that it is arbitrary. The counsel would like to state that it has already been decided in Quixote that we can only rely on legislative wisdom to determine what is genuine defection and what isn't. I mean, genuine dissent and what isn't, Your Lordship. Your Lordship, counsel would, if with the permission of the court, would like to share the appropriate paragraph to the judgment, Your Lordship.
Please do so.
Yeah. My co-counsel will be sharing page 902. Your Lordship, this is with regards to determining what is split and what is honest dissent, Your Lordship. Your Lordship, counsel would like to contend that this very same argument applies to mergers as well as other cases, Your Lordship.
Which para are you referring to?
Para 52, co-counsel.
Go to para. Is this the ratio of the matter?
Yes, Your Lordship.
Or is this just a discussion?
Your Lordship, this is the ratio of the matter, Your Lordship. You have to look at it. The court will rely on.
Please go ahead.
The court will rely on Justice Oliver Wendell Holmes' freedom of speech and expression to say that we can only leave it to legislative wisdom to decide certain matters, Your Lordship. And Your Lordship, counsel would like to now move on to page 894. Page 894. That is para 34. Yes, Your Lordship, in the very same, the court has held that court is again relying on Justice Oliver Wendell Holmes' free speech and living constitution, held that in an experimental democracy there are both pluses and minuses. And
how is this the ratio of the matter? This is just an observation. This is a reference to Justice Holmes.
Your Lordship, by stating that relying on Justice Oliver
Wendell, you can't rely on the discussions of the matter, right? You have to rely on the ratio of this matter. What is the ratio of this matter?
Yes, Your Lordship,
there are several things discussed during
no, you can't.
judgment.
You could go. No, there are paras for you. There are paras against you. What is the summary of the order? What was decided in this matter? Can you summarize that?
Your Lordship, indeed, Your Lordship. Your Lordship, the court clearly held that we can only leave it to legislature to determine what is genuine and what is not genuine, Your Lordship. That is what the court has clearly held, Your Lordship. And this is merely for providing the rationale behind why the court has held the same, Your Lordship.
Okay, we don't need to go through the discussions of that. This was already decided in this matter. The legislature will have the power. Can you further get into it? How will the legislature decide this? By way of the speaker, how is it? Can you explain this to me?
Your Lordship, with respect to the decision, the line, Your Lordship, where what amounts to defection and what does not amount to defection.
Okay. They will be able to. So it will be the speaker's job to decide what amounts of defection, what doesn't amount of defection.
Indeed, Your Lordship, the courts have time and again, Your Lordship, for instance,
isn't that argument number 2? Your argument is whether anti-defection law violates the Constitution.
Yes, Your Lordship. Your
This
Lordship.
reason of the legislature having the power to decide, okay, this was already held. Of course, I believe it was held there. But the powers of the speaker are there. Now you have to convince us on the principles, whether or not anti-defection law is against the Constitution of India or not, violative of the Constitution or not.
Your Lordship, indeed, Your Lordship. Your Lordship, I would like to respond to what, with the permission of the court, respond to the very argument which has been put
Yes.
forth by the opposing counsels.
Yes.
The opposing counsel had argued that an individual member would, if he moves to a party, that would amount to defection, and hence it is unconstitutional and arbitrary. That is what been stated by the opposing counsel, Your Lordship. Your Lordship, counsel would like to direct the court's attention to citation number 3, that is Incong Inchen versus Union of India. The court has provided the rationale for why that is in fact constitutional, Your Lordship. The court held that when an individual member defecting to join a party, then that would amount to betraying the very trust which has been held by the people. Your Lordship, counsel would like to furthermore reiterate on the very argument which has been put forth by the opposing counsel. Opposing counsel has stated that there is no differentiation as to what is support, Your Lordship. If there is support, the opposing counsel stated that that would also amount to defection. Your Lordship, the respondents humbly submit that this does not amount to defection, and the Honorable Court, Your Lordship, counsel would like to direct the court's attention to citation number 4, Your Lordship, wherein Jagdeep Singh was, in the case of Jagdeep Singh versus State of Haryana, the court clearly determined and differentiated as to what amounts to support and what does not amount to support and amounts to defection. So there is a clear law as to what amounts to defection and what amounts to not defection, Your Lordship. Furthermore, Your Lordship, learned opposing counsels had argued in favor, stating that it is violative of Article 194. Your Lordship, that is freedom of a legislative member. Your Lordship, this has also been contested against in the majority, Your Lordship. Majority judgment in Quixote, Your Lordship. Your Lordship, counsel...
You can't simply refer to the Quixote judgment over and over again. No, I know this has been decided in your favor once. But we need you to argue, not just refer to Quixote every now and then.
Indeed, Your Lordship. Your Lordship, it should be noted that this...
Can you repeat on your answer to the classification? The case of the petitioner is that the classification is not based on intelligible differentia. Now, argue against this point and tell me why it is based on intelligible differentia.
Your Lordship, that is why the respondents have relied on Oliver Wendell Holmes, Your Lordship, to state that there is no single test to determine what is constitutional and what is not constitutional, Your Lordship. And Your Lordship, counsel would like to give an analogy, Your Lordship.
Yes, please.
Your Lordship, section 82 and 83 of the IPC deals with Dolly incapax, Your Lordship. That is incapacity of when a minor commits an offense, when he's below the age of 7, it is not to be considered a crime. And when in section 83 states that when the minor is above 7 but below 13, he is to be convicted of the crime only if he knows the nature of the offense. Your Lordship, in this present case, let us say that a person just 1 day below the age of 7 commits an offense and he is well aware of the nature. Your Lordship, however, there has to be a line drawn by the legislature, Your Lordship. And one cannot say there is no intelligible differentia, since a 6-year-old boy is well aware of the nature of the crime. Your Lordship, that is the very contention which counsel would like to put forth.
How are you drawing the parallels between the two?
Your
Sorry?
Lordship,
Ma'am, you're saying something?
Yes, I said, how you are drawing the parallels between the two?
indeed, Your Lordship.
Your illustration is confusing us more.
My apologies, Your Lordship. Your Lordship, it's simple that it should be left to the legislature to determine and draw the line, Your Lordship. as to what would amount to defection and what would not amount to defection. And similarly, Your Lordship, in the IPC, it is left to the legislature to determine what would amount
Tell me
to
something,
cases.
if the majority party is created by a lot of other party members defecting and creating the majority party, why will the legislature decide against it? Shouldn't there be judicial review of this? Shouldn't this be set aside? Shouldn't this be not left alone to to the legislature to decide? Because they'll always decide in their own favor.
Your Lordship, with regards to Your Lordship,
Continue.
however, Your Lordship, Your Lordship, issue 2 will be dealing with how there is a mechanism, judicial mechanism for Your Lordship, wherein, as rightfully pointed by both Your Lordships, there's a mechanism for review, Your Lordship, to uphold the constitutionality in cases, Your Lordship.
Mm.
Your Lordship, if Your Lordships,
Continue. Without asking
yeah.
permissions, please continue.
Your Lordship, just one more submission with regards to issue 1, Your Lordship. That is, there also exist 2 exceptions, Your Lordship. In para 2, subpara 1, clause B, Your Lordship, wherein the para itself provides exceptions, Your Lordship, where one member obtains prior permission from his party, or when he has not obtained permission, but his actions have been condoned by the party. So, Your Lordship, Council would once again like to rely on Quixote, Your Lordship, but
Aren't you making a dictatorial party in a democracy where the party decides it all? You need to take permission of the party. You need to, it has to be condoned by the party if you are voting against the party. Shouldn't one person have their own freedom to express themselves? Shouldn't he be allowed to vote if he does not find it right? What is the majority in the majority party going against some minority, and this member is a minority person himself, and he votes against the very let's say any voting which is happening in the house, and he votes against it as he believes it will go against him and his people, and for that reason alone he should be he should be disqualified. This makes no sense whatsoever.
Your Lordship's Council very well agrees that debate and discussion is a healthy purpose for the functioning of a democracy, Your Lordship. However, Your Lordship, one should also be noted that so is political stability. That is, a political party functions on the strength of shared values, Your Lordship. And as stated by Quixote, Your Lordship, it would, quoted by Quixote, it would embarrass public image and confidence if members were to vote as they please, Your Lordship.
Are we there to ensure that the party does not get embarrassed? Are we there to ensure that a political party gets its will? It takes only some to make a democracy into a dictatorship. Why do we empower a party to do this? We are here for the people and we're here for individual rights. We do not care what every party has to do or what embarrassment it can cause to a party.
Indeed, Your Lordship. However, that very rationale is that the very trust which the members have is that it's the members, I mean, the people trust that that person based on their party, Your Lordship. And that is why, Your Lordship, Jagdeep Singh determined, differentiated
Not
as.
really. People appoint their leaders on the basis of the work that they have done.
Indeed, Your
Hardly.
Lordship.
It happens at the time of parties, but it can't be said to be 100% because of the party itself.
Indeed, Your Lordship. However, Your Lordship, that is the reason as to why Jagdeep Singh has determined and differentiated as to what would amount to support and what would amount to defection, Your Lordship.
What would amount to support? Can you explain that?
Your Lordship, that the court has clearly held that will rest with the speaker. That is, Your Lordship, council will be dealing with that with issue 2, but the court even then.
So basically, in summary, your arguments are basically you referring to either Kyoto or your speaker number 2.
No, not Your Lordship. Issue number 2 will be dealt by me, Your Lordship.
I know, but you most of them are generally answered in issue number 2 or by the judgment of Kyoto.
Yes, Your Lordship. It relies on the fact that there exists.
Conclude your argument, please.
Yeah, and Your Lordship.
That exists does not give you the right to simply say, please rely on that, right? If you are issued notice in this matter and we are hearing the final arguments in this matter, that means you have to argue the matter again from scratch. I
Indeed.
know it gives you a better, it gives you something over your opponents here that allows you to rely on that, but not all the time.
Yes, indeed.
Continue your arguments.
Your
In
Lordship,
fact, I think you have 2 minutes left. Summarize your arguments
Your Lordship,
without referring to Kyoto.
Your Lordship, Council would like to proceed to issue 2, Your Lordship.
Okay, continue.
Your Lordship, issue 2 is whether the conferment of speaker, the power of the speaker to decide on the question of disqualification is vitiated on the grounds of bias and is violative of the basic structure, Your Lordship. Your Lordship, it is humbly contended that it is Your Lordship, Council would like to humbly contend on the following lines, Your Lordship. Learned opposing counsel had stated that Your Lordship, the learned counsel would like to state that since the majority which decides the tenure of the speaker, hence he's biased. Your Lordship, counsel would like to contest this very statement by saying that mere fact that he is part of a party does not mean that he would be biased, Your Lordship. Even Your Lordship, it is contested that even the president can also be biased, Your Lordship, and which the learned opposing counsels have relied on the dissenting opinion. Your Lordship, the learned dissenting judges have relied on Article 103 and 192, Your Lordship, wherein the role of the governor or the speaker in disqualifying the member. Your Lordship, even in such a case, Your Lordship, they can also be subject to bias, Your Lordship. Hence, it is the humble contention that such a stance has no standing, Your Lordship. Furthermore, Your Lordship, counsel would like to also state
How
that
you simply state that they can be subject to bias and that has no stand. How have you come to this conclusion?
Your Lordship, they had relied on the principle.
Don't tell me what they have relied on. Tell me on what you are relying on. Your
Your
search
Lordship,
will come later, no?
indeed.
What are you relying on to say that this is not against the basic structure? Tell me what is the basic structure.
Your Lordship, in
What is
case
the basic? No, don't rely on cases in the Bharati. Tell me what is the basic structure doctrine.
Your Lordship, the basic structure doctrine states that which is the basic part of the constitution which cannot be amended by the legislature.
Okay,
Under
and the basic part of the constitution which cannot be amended.
Your Lordship, under 368, it cannot be amended, and that was held in Keshan and the Bharati, Your Lordship.
Okay, continue.
Your Lordship, it should be noted that there exists a judicial redressal mechanism, Your Lordship. The dissenting opinion had only opined that there exists no mechanism for appeal. Your Lordship, however, in the case of Union of India, which is Jyoti Prakash, Your Lordship, and other cases as well, Your Lordship, the courts have clearly held that Para 6 does not exclude jurisdiction under Article 226, and nor does it exclude the jurisdiction under Article 32 of the Constitution, Your Lordship. Your Lordship, furthermore, Your Lordship, it should be noted that even the remedy under Article 136 is available as well, Your Lordship. Furthermore, Your Lordship, in Jagdeep Singh case, as stated earlier, as well as Ravi S. Naik, the courts have further on went to state that judicial review is available in cases of malafidiness, ultra vires, and when principles of natural justice is being violated, Your Lordship. Here, hence, Your Lordship, clearly the law accommodates the possibility of a mechanism for appeal, Your Lordship, unlike what has been stated by the petitioners. Furthermore, Your Lordship, counsel would like to state that the right to voting under Article 100 Clause 1 would not have been granted to the speaker if the makers of the constitution were of the belief that he is biased, Your Lordship. And Your Lordship, counsel, if Your Lordship is satisfied, counsel like to rest.
Okay, speaker number 2, you may start.
It's permission to
Your voice might be problematic. Can you repeat again? Can you speak
Your
again?
Lordship, a council for the Union of Indigo seeks to address the bench collectively as your Lordships.
Yes, please.
Much obliged, Your Lordship. The Lordship, Speaker number 2 for the respondents would like to add on and submit that paragraph 7 of the 10th schedule is severable from the rest of the schedule and its invalidity does not affect the constitutionality of the entire 10th schedule.
What is para
Your
7?
Lordship, it is Your Lordship, para 7 is the bar on review of the codes, Your Lordship.
Can you read out the para 7, please?
Yes, sir. Yes, Your Lordship, sure. Your Lordship, notwithstanding anything in this Constitution, no court shall have any jurisdiction in respect of any matter connected with the petition of a member of a house under the schedule.
Okay.
Your
Continue.
Lordship is such.
Mm-hmm.
Much obliged, Your Lordship. Your Lordship, the respondents would like to draw the attention of this Honorable to the case of RMD Chamarbag Bala versus Union of India, where this Honorable Court laid down the following test for applying the doctrine of severability. The
Okay.
test of severability is whether valid parts are so connected with the invalid parts as to form an integral whole which cannot be separated without destroying the object and purposes of the act. If the valid and invalid parts are so interdependent and interwoven that they cannot be separated without destroying the object and purpose of the act, then the act as a whole must be struck down. But if the valid parts can be separated from the invalid parts without destroying the object and purpose of the act, the valid parts can be upheld. Your Lordship, applying this test to the present case, it is submitted that paragraph 7 of the 10th schedule is not so connected with the rest of the schedule as to form an integral whole which cannot be separated without destroying the object and purpose of the schedule. The object and purpose of the schedule, Your Lordship, is to curb the menace of defection and to preserve the stability and integrity of the parliamentary democracy, which, Your Lordships, can be achieved without paragraph 7. Paragraph 7, Your Lordship, it is humbly submitted, is a merely procedural limitation, which does not affect the substantive provisions of the schedule. Therefore, Your Lordship, paragraph 7 can be severed from the rest of the schedule and the rest of the schedule can be upheld. The respondent
You are
also
arguing that let para 7 go and rest of it should be upheld, right?
Indeed, Your Lordship.
But have you argued on the issue number 2 whether the Speaker of the House just sec. Whether the Speaker of the House has the power to decide on the disqualification of a member? Are you directly arguing on para 7? Then let this be set aside and the courts decide on what the Speaker is speaking. What the Speaker is passing an order on. You're dealing with 2 issues, right?
Your Lordship, I'm only dealing with the third issue, Your Lordship. My co-counsel Speaker
Okay,
1,
he's covered
Mr.
that issue
Vaishnav,
also.
dealt with the
I thought
first
you'd
and the
be
second
dealing in
issue.
detail. Okay.
You are not going to deal upon the speaker's issue.
Sorry, Your
I
Lordship,
thought
could you please?
the issues were, the first speaker covered them in passing. I thought you were going to go.
Yeah. I also thought the same.
No, Your Lordship, due to a constraint, lack of time,
Understood.
Yeah.
Continue.
Speaker 1.
But I'd like just a clarification on this. Petitioners, have you argued this point? Just a second.
Indeed, Your Lordship.
Petitioners, have you argued this point?
Yes, Lordship, we have argued on the speaker's wala point.
No, not on the speaker, where a para 7 on the 10th schedule is severable from the rest of the schedule. Because
No.
what they're doing is an arguendo for them. That even if you do uphold the rest, this even we believe should be set aside and removed. Because we believe in judicial, supervision over the speaker's orders. Am I right, respondents?
Yes, Your Lord.
But since petitioners have not argued it, you don't need to cover it. But as you arguendo, you can go ahead and complete it. Go ahead.
Much obliged, Your Lordship. Your Lordship, the respondents would also like to refer to landmark judgments of this court, Honorable Court, where the doctrine of severability was applied to constitutional amendments, which are relevant to the present case. Your Lordship, in the Keshwananda Bharati versus State of Kerala, the Honorable Court upheld that the Constitution of India has a basic structure which cannot be altered or destroyed by any amendment. the Honorable Court struck down clause which those clauses excluded judicial review of constitutional amendments as they violated the basic structure of Constitution. However, the Honorable Court upheld the rest of the 24th Amendment Act 1971, which inserted upheld the rest of the 24th Amendment Act 1971. Similarly, Your Lordship, in Minerva Mills versus Union of India, the Honorable Court struck down clauses 4 and 5 of the Article 368, which were inserted by the 42nd Amendment Act of 1976, Your Lordship. And however, the Honorable Court upheld deemed only those clauses to be void and upheld the rest of the 42nd Amendment Act 1976, Lordship. Lordship, similarly, in P. Samamurthy versus State of AP, the Honorable Court struck down clause 5 of Article 371D, which was inserted by the 32nd Amendment Act of 1973. However, this Honorable Court upheld the rest of the 32nd Amendment Act of 1973, which inserted the said article. Your Lordships, these judgments clearly show that this Honorable Court has applied the doctrine of severability to constitutional amendments and has struck down only the invalid portions of the amendments while upholding the rest of the amendments.
Good.
Your Lordship, the question whether a particular provision of an act is severable or not depends on the connections between the valid and the invalid parts as submitted before Your Lordship. Your Lordship, referring to the case of Bribery Commissioner versus Frederick Ranasinghe, which is a Privy Council judgment, an appeal from the Supreme Court of Ceylon, Your Lordship, this case is relevant in this in these proceedings because this judgment was relied on in the Kyoto judgment, Your Lordship. Your Lordship, Council will now say how will now argue how this case, Bribery Commissioner versus Frederick Ranasinghe, is relevant in the present proceedings. Your Lordship, in Bribery Commissioner versus Frederick Ranasinghe, the question that arose was whether a particular provision of an act is severable or not, and what it depended on. And the dependence was based on the connection between the valid and the invalid parts. Your Lordship, the same principles were may be applied to the present case and held that paragraph 7 of the 10th schedule is not so closely connected with the rest of the schedule, Your Lordship. Therefore, it may be observed that paragraph 7 of the 10th schedule may be severed, is severable, Your Lordship. Your Lordship, the respondents would also like to submit that there is no proviso in Article 368(2) which excludes the doctrine of severability from being applied to constitutional amendments, Your Lordship. Your Lordship, it is clear from, therefore, Your Lordship, the respondents humbly submit that the doctrine of severability is applicable to the constitutional amendments and hence paragraph 7 of the 10th schedule can be severed from the rest of the schedule without affecting its constitutionality, Your Lordship.
Understood. So, to summarize your arguments, you're okay with para 7 go completely, and you're okay with the Supreme Court having the power to oversee whatever the speaker is doing, the activities of the speaker, his orders regarding disqualification of members.
Indeed, Your Lordship.
Okay. Continue, guys. Are you done with your arguments?
Council would like to humbly put forward one more submission, Your Lordship.
Okay.
Just an extension of the points already put forward. It is, Council would like to humbly state that the test of severability necessitates an inquiry into whether the legislature would have enacted the law as the proportion subject to severance and whether the remaining provisions can stand independently and function effectively post-severance. The respondents would like to draw the attention of this Honorable Court to the legislative history of the 10th schedule, which reveals the primary motive and objective of the constitutional amendment. In the report of the Committee of Defections, which was constituted in 1968 by the Government of India, under the chairmanship of Mr. Chavan, the committee submitted that.
No, who was heading the chair? Who was heading the committee?
Shri Y.B. Chavan was heading the committee.
Okay.
Your Lordship, the committee submitted and recommended the insertion of a new schedule in the Constitution containing provisions for disqualification of members on the grounds of defection. The committee observed that the evil of political defection has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object in view, Your Lordship, the committee has examined the problem in all its aspects and have formulated the conclusions and recommendations in this report.
How are they
Uh,
relevant for you?
Your Lordship, council would like, Your Lordship, the council would like to state that these reports and bills submitted show that the constitutional amendment and the introduction of the 10th schedule were primarily motivated by the imperative to mitigate the adverse effects of defection on the political landscape, Your Lordship.
So you're relying on a report to support this amendment, to support the schedule.
Yes, Your Lordship.
What if the report was itself biased? If the report is made by the majority of the somebody who's connected to the majority legislature party, then they'll definitely support this schedule. Are there any judgments in support of you which you already have? So don't rely on reports which are made by politicians itself.
Indeed, Your Lordship. Your Lordship, Council has no further submission to make, Your Lordship.
Okay.
Council would like to move forward with the prayer.
Don't need to refer on the prayer. We already know the prayers. Now, petitioners, I would like you to, rebut on this issue, severability. They are saying they're okay with everything. Don't just remove 0.7. What is your answer to that? Should all of it go or only 0.7? Because we are also okay with that. Who will be covering? Speaker 1 or 2? Mahi, will that be you?
So my co-counsel would deal with this separability one issue.
Okay.
Your
That
Lordship,
part is regarding the bar to courts jurisdiction.
Your Lordship, if it may please you, please refer to the tab.
I think you should
This is
switch
the
the camera.
website of Ministry of External Affairs.
There's a problem with your audio, I believe, or it could be from my end also. Can you just switch off your video and so we can? It might get better.
I'll just rejoin. I'll have issues with my device.
No, I'm talking about your camera screen. That's it. Continue, Shrey. Shreya, are you there?
I apologize for this.
No issue, no
delay.
issue.
Your Lordship, I'll request your attention to the tab I'm sharing. This is this is the official website of Ministry of External Affairs, which lists out the Schedule 10 as a PDF form. Following my cursor, this is the para 7, which is
We have it.
related to bar. Yeah, so it has been started to refer here as that para 7 has been declared invalid for want of ratification in accordance with the proviso to clause 2 of Article 368 as per majority opinion in Quixote Holon versus Achille. Therefore, it is submitted that since the majority of the arguments by the side respondent were based on the Quixote Holon versus Achille case, but they left ignorant on the very crux of the case, which invalidated Paracel.
Good point. Continue. Now, you have any other points to make?
No, Your Lordship.
Okay. Do you have anything, respondents? Since your entire speaker number 2 spoke on an issue which is already declared invalid, did you forget to see the footnote?
Indeed not, your lordship.
Vaishnav, I'd expect Rohan to respond on this because since it was his issue.
Your Lordship, we did not.
Why were you arguing something which was already invalid?
Your Lordship, the petitioners were seeking to declare the entire anti-defection law unconstitutional, Your Lordship. And
Yes.
one of the arguments that they raised was the bar on judicial review by the courts, Your Lordship.
I get the point that since on a realistic level, without getting into the whole court situation, I get it that you guys must not have seen each other's memorial before the hearing, or did you guys get to see each other's memorial?
No, Your Lordship, we received it 15 minutes before the.
Look at the issues, no? That is important. Because this was, that is why I checked with them, because this was not even an issue covered by them. And you dedicated 15 minutes to an issue which was not raised by the petitioners. The respondent can't respond to an issue. And it's okay. It's okay. Do you have anything else to rebut? Because your issue number 2 is gone.
Would you
Vaishnav,
like to add about the
yeah.
speaker's issue if you want to?
you can add some more issues if you want to rebut.
Because the argument which you advanced were not relevant. So would you like to cover that issue? Because it was an important issue.
Yes, your lordship. Lordship, as argued earlier, your lordship, that is in fact the very dissenting judgment which learned opposing counsels had relied on was the dissenting opinion that in Quixote, your lordship, counsel would like.
So you are also relying on the majority opinion. How
Indeed,
is
your
that?
lordship, the counsel would like to state that the dissenting opinion had erred in their rationale, your lordship, and counsel would like to state as to how, your lordship.
Okay.
Your lordship, in para 182 of their of the judgment, the court has stated that there is no mechanism for appeal.
I can't see para 182. Can somebody share?
Yes, the page 958. I request my co-counsel to. And 58 para 182. Your lordships, if you have to look at it, your lordship, the court
Is
has
this an
stated,
observation again or discussion? I need an answer on this.
your lordship, court provided the rationale for making giving their decision, your lordship. Your lordship, since the petitioners had relied on this very same judgment, your counsel would like to state that the judgment itself has erred, since there exists a judicial mechanism, your lordship. As stated, your lordship, the courts have clearly held that there is a judicial mechanism available under Article 226, under Article 32, as well as under Article 136, your lordship.
Just tell me, is para 182 a part of the observations made or the discussions?
Your lordship, it is an observation, your lordship, since the court, by providing this rationale, had come to a conclusion that it is in fact, the para 6 is in fact biased, your lordship, and is violative of basic structure. That is what the dissenting judges had stated.
Okay, got it.
Your lordship, furthermore, your lordship, in other cases as well, in Luis Proto Barbosa versus Union of India, the court had even extended the purview of judicial review to cases wherein cases of para 5, your lordship, wherein the speaker is not disqualified when he leaves a party. Your lordship, in the particular case, the court, the speaker had left his party, and he had stated that since para 5 exempts him from being disqualified on the grounds of defection, he is still to be the speaker. There's a court held that the court determined the partiality of the speaker and stated that In such a case, the speaker is also to be disqualified on the grounds of partiality, Your Lordship. So there is in fact the courts have in fact clearly determined as to what is how the judicial mechanism, Your Lordship. Court has clearly.
But do you believe that the speaker should be an adjudicating authority? Because he may have taken allegiance to the constitution. Every MP or every MLA has to do that. But still, he is bound to one party.
Your Lordship,
Can he be an impartial adjudicator? And though his decisions are subject to judicial review, but there cannot be any, there is nothing about when within what time frame he should take the decision. Look in Maharashtra what it is happening. The speaker has not yet taken the decision. The courts haven't forced them to take any decision in a time bound manner. They
Your
can
Lordship.
review the decision, but till the if the speaker just sits on the file, he doesn't take the decision at all, then what to do? So will the speaker, should the speaker remain an adjudicating authority? Is it right, or that part should go?
Your Lordship, counsel would like to first deal with the part of whether court has the power of judicial review in cases of wherein the speaker does not take a decision, Your Lordship. Your Lordship, in many cases, Your Lordship, the courts have actually determined and stated and has ordered for a speaker to actually look into such a case, Your Lordship, and to decide on such a case.
Can you give some example?
Indeed, Your Lordship. Your Lordship could.
I have given you one example of Maharashtra, my state.
Indeed, Your Lordship. Your Lordships could. A minute, Your Lordship.
Because I think you are saying that the courts have directed the speaker to take the decision in a time bound manner. Is it what you want to say? Are you trying to say that?
Indeed, Your Lordship. Courts it is a high court judgment, Your Lordship, but counsel would like, if Your Lordship could give me just a minute, Your Lordship, counsel would.
Sure.
Yes. Your Lordship, it is the case of Bahujan Samaj Party versus Speaker Rajasthan Legislative Assembly, Your Lordship. Counsel would like to give the citation as well, Your Lordship. It is 2020 SEC online, Your Lordship, Rajasthan 2006.
Can you share it on the screen?
Lordship, the judgment, indeed, Your Lordship.
If you have, otherwise it's okay.
Your Lordship, it is not opening, Your Lordship. Counsel seeks a
Just
court's
refer to the ratio of the matter, please.
Your Lordship, the ratio of the judgment, Your Lordship. Your Lordship, that
where the court have.
Indeed, Your Lordship, court has actually brought in the abstinence of the speakers to take a decision within the purview of a judicial review, Your Lordship. In such a case, the court actually went on to order the speaker to take a decision, Your Lordship, either to disqualify or not disqualify, Your Lordship.
That is a different thing. That it is his right to take a decision. Can the court direct him to take? It's about time. I gave you the realistic example of State of Maharashtra.
Indeed, Your
Speaker
Lordship,
is not taking the decision at all. What the court has done.
Indeed, Your Lordship, that as stated earlier, Your Lordship, the court brought this within the purview of judicial review. So, court actually went on to order the speaker to take a decision.
Within how many days?
Your Lordship, I'm not sure.
Because even in Maharashtra also the speaker is directed to take a decision. But
there was a time period also given, Your Lordship.
What is the time period?
With respect to the names. Your Lordship, I am not sure, Your Lordship, but Your Lordship, it was
okay, whether some time was given or whether a time frame was given or not.
Indeed, Your Lordship, court had, this was with regards to 6 BSP MLAs, Your Lordship, with regards to Congress. Lordship is unable to open the very document, Your Lordship. Council seeks a
It's
court.
okay. It's okay.
Your Lordship, furthermore,
Let
Your
me
Lordship, as stated earlier, Your Lordship, there is only a bar on judicial review in cases of procedural infirmities, Your Lordship. And in cases, as stated earlier, Your Lordship, in case of bias, I mean, in case of malafidiness, ultra-virus cases, and when cases which infringe natural justice, Your Lordship, in such a case, judicial review is available, Your Lordship. And Your Lordship, this is as stated earlier, Your Lordship, Jagdeep Singh versus State of Haryana, as well as Ravi S. Naik, they went on to further delve into this, both principles of natural justice as well as malafide cases, Your Lordship. So it is a humble submission before this honorable court that there exists a judicial mechanism, and it cannot be stated that this position of a speaker is biased. And finally, Your Lordship, the final submission, Your Lordship had stated that since he's part of the political party, he cannot be expected to be biased. Your Lordship, the same would apply for case of Article 103 and 192 as well. Your Lordship, Article 103 and 192 rest the power of this disqualifying a member, be it a state legislature or a central legislature, parliament, to the governor or the president, Your Lordship. Your Lordship, it cannot be stated that since he is not part of a party, he is to be unbiased, Your Lordship. It is a humble submission that there is also a possibility of bias, even then, Your Lordship.
Are you saying the speaker has the right to be biased?
Indeed not, Your Lordship. The council will like to state that the very possibility exists for the president as well as the governor, Your
Exactly.
Lordship.
That is
So-
what the petitioners are against, that they don't want this bias to happen so that judicial review is there.
Well,
So just
indeed,
because there's a possibility, should we allow this to happen? Since it's happening in so many states right now.
Your Lordship, council would like to rely on G.V. Mavalanka's office of speaker, and which was also relied on Kihoto, Your Lordship, wherein the court stated that this position is expected to be impartial, Your Lordship. And Your Lordship, when he takes the role of a speaker, one also takes in the robe of impartiality as well, Your Lordship. That is the humble submission of the respondents, Your Lordship.
Got it.
Your Lordship, the council.
Got it. I think we can call it a day now. I think all of them are done. Okay.
It's been a pleasure arguing with us.
Sir, before concluding, we request you to please give feedback so that they could improve in their further rounds.
So, ma'am, I think being the senior, you should start.
Actually, relying on authorities is fine, but only citing authorities after authorities, authorities after authorities, one should first explain the facts. It's not just, see, authorities will definitely strengthen your case if they are in your favor, if there is some landmark judgment in your favor, or if there is Supreme Court judgment, High Court judgment, whatever. And this may be a Supreme Court judgment that will give more weight to your arguments. But first of all, you should be able to explain the facts, then apply the authority. Just citing authorities after authorities. In this case, this is held. In this case, that was held. That's okay. It is not a, see, argument of a council is not just a compilation of authorities. One should be able to first understand and explain what is the facts of the case, what is the law applicable to that, and how your case is covered either under the existing law if you are defendant. It means if you are saying that this law should remain, this law shouldn't be struck down, then you should say why it is required. First, go into why that law was enacted. If it was enacted, what was the purpose? Go into that, argue on facts more and the law, and then as a support, take the authorities with you. Means use the authorities as a support, not just a compilation of authorities. That is what from whatever arguments I have heard, I would like to bring this one point to the notice. And what reliefs you are seeking, that is the most important thing. Because in the flow of the arguments, what you are exactly seeking goes away. That shouldn't happen. So your whole argument should be centered around exactly what are the facts. If you are coming before the court for as in a PIL, how you are entitled to file that PIL? Means one may say you are neither a disqualified MLA, you are nor you are a disqualified MP. Why are you coming before this court? Means what is your locus standi? Explain that also wherever it is required. In any case, I'm not talking about only in this case. In a cases like PIL, preferably, and main go upon facts, law, and support it with authorities rather than compiling, making an argument a compilation of authorities. Because ultimately you are coming before the court, then the court has every right in case except it is if it is a higher bench, means larger bench that has given that ruling, the court can definitely take a dissenting view. So whatever may be the authorities you may be having, the court can take a different view. It has happened multiple times in the Supreme Court. The earlier the courts have taken some view, that court that the another means subsequently a law goes on evolving. What was the view of the court in 1950s, what not in 1970s or 60s? It changed. And now also the views of today's judges or who are sitting in the Supreme Court, it is different. So just stressing fully on authorities or compiling your arguments with authorities won't be of much help, because court may take a different view.
Adding to what ma'am has said, there's so many cases of defection right now happening. So many currently pending and so many decided. I know you guys have made a compilation of all the judgments in this case, but what was missing, I would say, was the facts of each case. That would actually have given you a clear picture of why are you here as the petitioner, why are you here, is what is happening right now in India. Okay, so you just don't need to look into the law part of it. As a PIL and as an NGO filing this PIL, you need to understand why we are forced to file this. So understand the facts of each case more than the law. Because law, anyways, you have compiled well. I cannot deny that for both the teams here. But as ma'am said, you are relying majorly on the authorities. That does not help if the facts are not there. The facts are missing. And this is not for one party. This is for both the parties. The facts were missing. Your case should have been, this has happened in all these cases, as per the facts of each case. Yours should have been how these facts are not applicable in this case and how it has worked out for the better. Or how even the Supreme Court took a lenient view with regards to the powers of the speaker. And I know for the respondents, it's easier to rely on one judgment which is already, decided on this issue before. But you have to realize that 20 years from then till now, a lot has changed. So there's a reason that the PL was filed, entertained, and we are the final argument before a court. And for the respondents who are the Union of India, you have to go into the legislative intent. Same goes to the petitioner also. What was the intent behind, making this amendment, getting the schedule in place, and how it's not being followed?
Yes.
And don't try to plead ignorance. This is just a tip, not officially. Do not plead ignorance because it does not work out. But the judges look down upon it. In a real court, you will be allowed a date on this. You can take an adjournment on the basis of this, that I need to look into this or get instructions from my client, but not in the moot court. That becomes a problematic issue. So think of whatever you can answer. Think of it and then answer. As for with regards to the issue 3 problem, I understand you got only 15 minutes. We get months to prepare a file because they add adjournments and then you get to read on the file. But look at the issues that they are covering. You need to see only 3 things in their file, right? Citations being made, issues, and whatever they've argued. And you can see the issues in like less than a minute. So now, if you guys make it to the semis, I hope you do, then decide on who will be arguing the matter. Because issue 3 is literally an irrelevant issue at this juncture. So this is for you guys, for the respondents. For the petitioner, you already made the comments. Thank you guys. Thank you for joining.
Thank you, sir.
Thank you, sir.
Thank you.
Thank you so much, sir. Yeah, thank you everyone for joining.
I think